Good morning, Mr. Chairman, Member Graff, Assemblywoman Markey. I just want to thank you for your leadership in holding this hearing and listening to all of us, because there can't be any more of an important issue in the state and in our nation than protecting our children. I serve as the Executive Director of the National Center for Victims of Crime. The National Center is the leading advocacy organization serving victims of all types of crimes. Since 1985, we have been trusted resource for policymakers seeking to improve the nation's response to victims of crime. I'm here before you to support the New York Child Victims Act and to urge you to enact this important legislation which will protect children and provide an opportunity for justice in our most vulnerable victims. Mr. Chairman, you started this hearing by stating that this is not something that just happens in other places. 1 in 4 girls and 1 in 6 boys is sexually abused, and it's oftentimes by a family member, a father, an uncle, a visiting friend. If it happens outside of the home, it happens by people that children and their parents trust, a teacher, a coach, somebody that is well known in the community. Childhood sex abuse is a little like lung cancer. You may not really realize that the effects of it are because of something that happened to you years before. You were a smoker 25 years ago and you get lung cancer when you're in your 60s. You're a victim of child sex abuse, and you realize that the migraines you've been having for 20 years are actually related to the abuse that happened 20 years before. That's why a statute of limitations only helps the offender and doesn't help the victims, particularly young men. They're the ones that are least likely to come forward. There's always a delay, not always, but often a delay in reporting, and that makes the year 23 really not really a reasonable time to expect a victim of child sex abuse to come forward. So other states have already paved the way, as Professor Hamilton has told us. 41 states recognize the unique nature of child sex abuse by creating special statutes of limitation that give victims more time to come forward than it allows for other types of crimes. 11 states allow victims of child abuse a fixed number of years from an age of majority to file a civil suits. Of these states, Connecticut offers the longer statute of limitation, allowing victims to file suit up to their 50th birthday. 26 states do not even start the clock running until a victim knows that the harm they have suffered was caused by sexual abuse they experienced as a child. 4 states have completely eliminated the civil statute of limitations for child sex abuse. 3 states, California, Delaware, and Hawaii, have created provisions that allow old claims of child sex abuse to be brought without regard to the statute of limitations for limited periods of time. The statute of limitations is a legal loophole to let abusers run out the clock and avoid accountability. It's critically important to allow old cases to come forward in order to protect children, even when it takes a victim 30 years to come forward. We often find victims of sexual abuse that really don't recognize what's happened to them until they're in their 60s, 70s, sometimes even into their 80s. Eliminating the criminal statute of limitations, however, is not sufficient. We strongly support the elimination of criminal statute of limitations. It is critically important that abusers are held accountable both civilly and criminally, however. Eliminating justice for criminal statute of limitations will only apply to acts of child abuse that occur after the law takes effect, and those victims may not be ready to disclose the abuse for decades. In 2002, California passed both a civil and criminal window and allowed for the prosecution of cases beyond the statute of limitations, but the U.S. Supreme Court ruled that it was unconstitutional retroactively. Only the civil statute of limitations can be changed retroactively. I also would like just to say a few things about our opposition. Those who oppose the legislation will use various arguments, sometimes in public but often in quiet conversations, to spread misinformation and raise unfounded fears about the impact of this bill. I will address a few of those concerns. You will hear that it is unfair and impartial to defend old cases. The witnesses are dead and the files have been destroyed, which puts the defendant at a disadvantage. In fact, the opposite is true. A case such as that would fail criminally and civilly, because both the prosecutor and the victim have the burden of proof. Without any corroborating evidence, neither a criminal or civil case could survive preliminary motions. I think when we look at these cases nationally, I'd like to echo what Professor Hamilton has said. What we need is the elimination of criminal and civil and to create a window. That is the only way to create justice for children and for adults that recognize at a later date in life that they have been abused and they have been suffering for years because of it. As in your opening statements, we hear about cases like this from places that we never thought we would hear them from. The schools that we love, the children's TV shows that all our children watch. And so without these kinds of protections, this kind of abuse is going to continue to go forward and perpetrators are going to be left off the hook. I urge you to pass legislation as soon as possible. Thank you.
Thank you.